And our guest today is an expert commercial real estate attorney, Krista Kim of Valence Law. And she'll be talking about commercial lease options during the COVID-19 downturn. As shelter in place continues, most offices, stores, restaurants, and virtually all other business spaces remain unused. And many business owners are rightfully wondering if they have any rent relief built into their lease documents for events just like this. Or if not, how to best approach their landlord if they're having difficulties paying rent, or if they will no longer need the same amount of space that they originally leased. And to answer some of these questions today, Krista is joining us to help tenants understand the key areas of their lease agreements and strategies for possible rent reductions or downsizing opportunities. Krista is incredibly well qualified to speak on this topic because she's the go-to commercial real estate attorney for both tenants and landlords. And having to work on both sides, she finds herself having these conversations on both sides of the fence. She's the founder and managing attorney of Valence Law Group, which is a boutique real estate law firm here in the Bay Area that specializes much of its practice on commercial leasing. Krista's firm has been very busy helping tenants review and negotiate commercial leases right up until the downturn. And as you can imagine, they're now even busier fielding questions regarding COVID-19 and helping tenants of various sizes navigate their commercial leases and obligations. So without further ado, I'm going to welcome and bring Krista into conversation. Hey, Krista, can you hear me?
Hi there, I can. Thanks for having me on.
Oh, it's a pleasure. Welcome. All right, so let's start, Krista, if you can just sort of set the stage and answer probably the biggest question that most business owners have on their minds is, is there any obvious provision in my lease that can provide any express right to abatement or relief?
Yes, so this is the question we get a lot. In fact, there was a Business Times article a couple weeks ago that talked about leases and mentioned the force majeure clause and said, force majeure clauses may support claims of rent relief. I had many clients calling me after that article and just conversations that they had with others saying, hey, I heard that if I have a force majeure clause in my lease that I might have a right to rent abatement. Can you tell me if my lease has a force majeure clause? So most leases, I'd say at least 75% of leases will have an express force majeure clause. A force majeure clause will excuse a tenant from being in default or a landlord from being in default for failure to perform an obligation under the lease to the extent the failure is attributable to force majeure. So the first thing you have to do is look to see how broad is the definition of force majeure. Force majeure is generally interpreted very narrowly, but many force majeure clauses will apply to acts of God. Some include references to pandemic. Some will state government shutdowns, failure to procure materials, other things like that, or any other event beyond the party's reasonable control. So, a lot of the force majeure clauses that we're reviewing are broad enough to cover COVID-19, but what they also say, and what the San Francisco Business Times article did not mention, is that they also state, even though they excuse a party's performance, and basically you can't put a party in default for failing to perform, they do not, and expressly do not, excuse a tenant's obligation to pay rent. That is almost universally in every force majeure clause in every lease. Even the most well-negotiated, tough negotiations, the big, 50,000 square foot, 100,000 square foot leases, all say the same thing. You can't put a tenant in default because it can't, maintain the HVAC during this time period, or a retailer can't operate during the operating hours, but the tenant is not excused from the payment, from the obligation to pay rent due to the force majeure clause. That said, the force majeure clause is still really important because there may be obligations that the tenant has that are in fact triggered or could be excused due to force majeure. If a tenant signed a lease and then is in the middle of constructing its tenant improvements, it may be able to push out the time period before the lease would commence due to force majeure. If it has a sunset period for use of its tenant improvement allowance, may be able to justify extending those dates. So it's still important to look at, but it's been a little bit of a disappointment to my clients and to people that I've spoken to, because they have reached out to me with the expectation that if their lease includes that clause, there's abatement, and that's actually not the case.
So the force majeure clause in and of itself does not give a lot of protection to the tenants necessarily. We have to really dig in to see if there's specific language that might provide the tenant with some relief, or maybe there are special circumstances, like you'd mentioned, a build out or something else. But what you're saying is there's not an obvious go-to clause, unfortunately, that we can use.
Correct. Yeah. Unfortunately, most force majeure clauses will specifically state that although certain obligations are excused, the obligation to pay rent is not excused.
Are there any, other areas in the lease that business owners should be looking at to see if they might have some points of leverage, or is it just really up to having a conversation and up to the landlord's discretion to decide?
No, so I will say there are a couple other provisions that we're always looking for when we review a lease. So a client will come to us, or it'll be a lease that we've negotiated. We'll take a look first, double check, see what force majeure says, and then we'll look at the service interruption provision. Not all leases will have this clause, but if the tenant negotiated the lease, it may have this clause, and depending on the strength of the negotiation or how sophisticated the form is, the provision may be quite broad, but generally it will state that if the tenant can't use the premises because of generally a service failure, lack of access, lack of HVAC, or if sometimes it'll have a broad catch-all, if the premises can't be used by the tenant for some other reason, then and that interruption continues for more than, say, 3 to 5 business days, then the tenant will be entitled to abatement after that time period. So this provision, we found a few leases where a tenant could use this provision, especially in buildings where the landlord actually shut it down. Although most leases, landlords are not completely shutting it down. They're just saying, hey, tenants, you can still access if you're an essential business, but you are required to comply with law. So you have to certify that the law allows you to continue to access the building, but the building is still open, the HVAC is still on, the electricity is still on. You could still access your premises. That way they could avoid tenants claiming that the landlord is shutting down services, so that the tenant could claim abatement due to failure to provide an essential service, or claim that the landlord is in breach of the lease. But going back to the express service abatement provision, even though some service abatement provisions are broad enough to perhaps justify abatement, most provisions will state that the tenant is not entitled to abatement if the interruption is caused by something beyond the landlord's reasonable control. So if the abatement or interruption is due to COVID-19, then the landlord is not required to provide abatement for something like that. So it's something that's important to look at, but it's also not a surefire path to express abatement under the lease. So I'll look at that provision. I will actually look at the takings clause, and I will look at the casualty clause, because sometimes they're drafted pretty broadly. The casualty clause, although it's meant to provide for abatement if there's a fire or an earthquake or other casualty, sometimes they're drafted maybe in a sloppy manner to state that if it's
a technical term, I'm sure.
Yeah, carelessly drafted casualty provisions may state that, if the tenant, if there's a casualty or other event which renders the premises unusable by a tenant, then the tenant gets rent abatement during that time period until the casualty is abated. So some of those clauses, it's worth taking a look at those types of clauses. Similarly with condemnation, if a government authority has stated that a premises may not be used, then a tenant could state that, that's a taking of their space. Some tenants have made that claim. I think it's yet to be seen whether they'll succeed if that's actually, taken to the courts. Generally, I don't think that would constitute a taking, but we're trying to look at every potential path. So we're looking at that clause as well. We're also looking at, what are the landlord's obligations? Are they complying with the obligations? Is the landlord providing access to the premises? and putting together a summary of what the lease provides. But as you noted, unfortunately, most of the conversations are, this is what the lease provides, but now let's set that aside and figure out, how do we get you where you need to go? And that's a different conversation.
I was just thinking back. I think it's probably the service abatement provision, if I got that right. But I was just thinking back, if, let's say, a business was having some issues with, and there's one in particular, I won't give away who it is, but there was one in particular where this business location had flooding during heavy rains, and the landlord would have to send in the property manager to somehow prevent the water from getting its way in. So whether it would be through sandbags and some other repairs. Well, it's sunny here in the Bay Area, but it may be raining somewhere else in the country. And if somebody's having an issue like that, but the landlord can't send work or workers to fix the problem for whatever reason, would that be grounds for asking for some rent abatement?
Well, that would be where the force majeure clause would kick in, but for the benefit of the landlord. So the landlord would say, it's my obligation to maintain the premises, and it may even state the level to which the landlord must maintain the building, Class A standard, Class B standard, consistent with other buildings in the area. But if the landlord is not able to maintain the premises because of something that's beyond the landlord's control, like COVID-19, inability to get workers, the landlord would not be in default for that. Now, the tenant still may have claims for abatement, but under different theories. And certainly if the tenant isn't in the space and not able to use the space because the tenant's complying with their own legal requirements, the question is, how is the tenant really damaged by that type of repair that's not being performed?
It's an interesting perspective. So that actually benefits the landlord, not so much the tenant. And
yeah, I'll say the force majeure clause is really meant. Most leases are drafted to protect the landlord. It's just been the way it is. And the force majeure clause is really meant to cover the landlord if the landlord can't comply with its obligations due to something that's beyond the landlord's control.
Right. Well, and knowing that you represent both sides, I know the majority of your work is representing tenants, but you do represent landlords, and I want to talk about that as well, because I'm sure someone watching this may very well be a landlord, and they may be dealing with some problems with tenants who may not be able to pay rent. But before we jump off the subject around the tenants' rights, if there isn't an obvious clause in the lease agreement that can help a tenant either get some rent relief or abatement, how do tenants think about approaching their landlord and have that conversation if it's not expressly stated in their lease?
Yeah, so it's a good question. And most of my clients will reach out to the landlord, or even if I'm on the landlord side, the letters that we're getting from tenants, they're very similar. They'll state that due to the unprecedented nature of COVID-19 and the disruption to the economy and to their business, they have maybe gone through reductions in force. They've had to implement various cost-cutting measures to protect their business, but they're hurting and they need relief. So they'll reach out to the landlord. Generally, they won't just say, hey, landlord, I'm not going to pay rent. They'll say, hey, landlord, I'm really hurting. I respectfully request that you entertain some relief and work with me through this. I'd like you to abate rent during the time period that the shelter in place is in effect. Or I'd like to work out some other arrangement with you. So most of the letters will have that overarching theme. The landlord responses will generally say, hey, we understand that this is a very difficult time. We also, we have our own obligations. We still have a mortgage to pay. We have operating expenses to pay. We will, provide us with your financials and more information about what difficulty you're facing, and we'll talk. But until then, we encourage you to continue to pay rent. So, it's overall, landlords and tenants really do have the lease is documenting a long-term relationship. Some of the leases that I negotiate, they may be 7 to 10 years in length, although, 5 years is pretty average. In general, if the tenant wants to be a tenant in the space long-term, they're going to want to find a solution that's not going to completely alienate the landlord. And if the tenant approaches the landlord with the relationship in mind, the landlord is going to be more accommodating and try to figure out a solution to really help that tenant stay long-term. It's the tenants that just send a form letter that, the landlord will just roll their eyes and say, oh gosh, look at this letter. It's not customized, it's not tailored, it's not explaining why the tenant needs relief. At this point, since there isn't anything in the lease expressly requiring a landlord to accommodate, it is really important to explain why. And if the landlord sees that if they provide you an accommodation now, you're going to continue to be in the building and continue to be a tenant, I think that landlord will be more willing to work with you as a tenant than if they think that this is just, something that's just going to continue in perpetuity. So it's a delicate dance because you want to show the landlord why you're impacted, but they also want to know you're not so impacted that you're going to completely go out of business. So it's, what are you doing to preserve your business? What are you doing to ensure the viability of your future? It's really, each tenant's going to have a different story. So those are important things to think about in approaching the landlords. I would also say, although I've been advising my clients and, summarizing what the lease says, kind of bouncing ideas off, helping them formulate a strategy, I'm not communicating with any landlords or tenants directly. I think the communication really should come directly from the business parties that have the relationship. I think that's most effective.
Keeping the attorneys away for now, not to make this more of a seemingly combative and making it a personal appeal.
Yeah, I think that is really important.
Does that change in any way based upon the type of landlord that one is working with, whether it's a kind of a smaller operation, maybe some mid-size that it has a property management company in place and not necessarily direct access to the landlord, all the way to your sort of institutional Class A type of landlords?
I think, so a lot of tenants who are leasing space in, high rise in San Francisco, they're not going to necessarily have a relationship with the asset manager or the ultimate owner. They'll have a relationship with a property manager. It's whoever that person has a relationship, they should start the communication there. So they may be sending a letter to the property management, and the property manager will forward that letter to ownership and sort of be in the middle of the conversation. If the tenant does know who the owner is, reaching out to the owner and having this be, some of my clients, like the CFOs, reaching out, letting them know, hey, we're going through hard times. It's, just like all tenants and all landlords too, everyone's sort of experiencing this at the same time. CFOs are reaching out, CEOs are reaching out. Sometimes it is the office manager who's reaching out and asking for relief. The other thing I do want to note is for San Francisco in particular, or Los Angeles or some cities, there are local orders or local rules that are, like in San Francisco, for example, a moratorium on commercial evictions. It was only for a 30-day period, but was extended. And so some of my clients are coming to me and saying, does this mean that I don't have to pay rent during this time period? What does this actually mean? So what it does mean is that a landlord cannot evict a commercial tenant that, I think there are certain criteria for what tenants qualify for this, but generally smaller businesses, if they don't pay rent, then the landlord can't evict them for a period of time. It doesn't mean, though, that after the time periods have told that rent will be forgiven. It just means that after this time period, the landlord can then finally exercise their remedies. So it may provide some relief for tenants that are, have cash flow issues right now and need to make a choice between prioritizing paying their landlords and paying staff or paying, other types of expenses that are very immediate. And so for some of those tenants, they may be making that choice, particularly retailers who have zero cash flow and don't have large reserves. It provides them some immediate protection that they won't be evicted. And practically speaking, a lot of landlords will probably work out something with those tenants in the future, maybe some sort of lease restructure, lease amendment to, you'll hear the phrase blend and extend, where, maybe we'll provide you in exchange for providing you some relief now, we'll tack that on to the end and extend out your term. The landlords would like that because it's a very uncertain market, especially if a tenant may be in its last 6 to 12 months of its lease term. Landlord may not view the market as being, that great of a market in 6 to 12 months. So it may be better for that landlord to say, okay, great, you know what? You can't pay right now. I'll give you 4 months of abatement right now. We'll do an 18-month extension. And then I know at least for 18 months, I'll have you and you'll see the goodwill of your landlord in working something out with you. So I am seeing some of those discussions, other types of restructures. Mostly parties are working together, which has been positive. What I'm not seeing though is landlords just giving express abatement in general, with very limited exceptions.
Well, it's encouraging to hear that at least there's conversations are taking place. And I think that, what did you call it? Extend and blend?
The blend and extend, yeah.
Like the other way around. That sounds like a really good option for some folks. And I imagine if they're towards the tail end of their lease, and maybe they've been worried about the way that this market has been going, that this may actually work to their advantage as well, because they can extend their current rates without having to worry about moving.
Yeah, and for landlords, it's good too, because I think there is a consensus, and I don't hold a crystal ball. I don't know what the future is going to hold, but I do suspect strongly that we are moving somewhat from a landlord market to a slightly more tenant-oriented market, just because of demand and vacancy. And because of that, brokers who know more about the rates than I do are saying that they do expect that rates are going to go down a little bit. I mean, they have to. They've gone up for so long that rates may go down. So because of that, and it's really going to take several months, maybe 6 months to even a year, to kind of figure out where rates are really going to go. Landlords may view extensions at current rates as a really good solution for them, because it may be that in 12 months, when they're renegotiating the term, those rates are going to be higher than market.
Right.
Yeah, and
That's a good
we'll
point.
probably see a lot of longer deals, 5 to 7 year deals. Tenants, prefer shorter term deals. We'll probably see some shorter term deals as people try to figure out what's going on in the market. There may be some of these as part of the blend and extend, just amended and restated leases.
Right. That's great. Before we move on to talking about landlord side of things, you'd mentioned one other thing that I want to come back to, and that is if a tenant is having some financial hardships, that in engaging into conversation with their landlord, they should in some way show their hand that they are in fact suffering, some financial hardship. Can you talk a little bit about what most landlords are looking for, so as to give our listeners a chance to prepare better for having that conversation?
Yeah, so the San Francisco order specifically states that in order for the tenant to get these extra cure periods for the eviction protection, they have to show the landlord that they are suffering from financial hardship. It's not really defined, but what I've seen some landlords request is, copies of financials. It's not going to really show anything right now, because we're literally experiencing this right now. But what they can show is how they expect their sales to have decreased. If they're a retailer, it's more, it's a pretty clear answer, which is, we've been closed and we usually make this much in sales, and now we're closed, so we're not expecting to make this in sales. And after we reopen, it'll take this much time for us to generate those sales. So those are the types of information that should be provided to a landlord. It's also some of the clients that are reaching out to landlords are indicating what they're doing to mitigate the risk to their damage or the risk to their business. So they're saying, hey, we've actually filed a claim with our business interruption insurance. We can talk about that as well. It's not probably it's not going to be very successful, but people should do it anyway. So we filed a claim under our insurance policy. We have reduced our expenses in the following ways. We expect our, revenue is still, we're doing okay, but our revenue has taken a 30% reduction or 30% dive. Just kind of formulating the story, but that it's not so dire, right? Hopefully it's not so dire that the business can continue. For some businesses, this may be insurmountable, and those businesses have a different story. They may not be asking a landlord for temporary rent relief. They may be trying to figure out a complete exit strategy from the lease. Some of my clients have leased a large premises based on assumptions that they would be growing and hiring more people, and those forecasts have changed. Instead of hiring 30% more staff, they're going to be reducing their workforce by 30%. So they no longer need that large space. So they're thinking about it. Do we subdivide part of it, bring in another occupant and take a smaller space? Or do we completely leave this space, subleases to another tenant who may have been in a larger space who's also trying to downsize? I think there are going to be some musical chairs going around with tenants kind of shifting spaces. Or some tenants may be trying to negotiate for exits out of the lease completely. I always recommend, sublease. The subleases are better if you want to. If a landlord is not going to agree for you to terminate, which again, most landlords are not going to agree unless there's some sort of consideration, termination penalty or something, and some just won't agree at all. But if they won't agree, generally your best bet as a tenant is to sublease your space because you have control over what your damages are.
All right. So there are a couple of things that you just said. I want to restate them. One, was that there's no specific financial package that like landlords are expecting to get from you in demonstrating that you have been affected by COVID-19 downturn, but it's more of a kind of a narrative story that you recommend for tenants to write about. And it's not so bad that we're out of business, but we could really use your help, and here's some kind of facts to support that. But the second thing, is that correct?
That's correct. Yes.
Okay. And then the second thing that you mentioned, which was in the back of my mind as well, is I've got more space than I need, for example. Is it a good time to start having that conversation with the landlord, or should this be completely done by the tenant in trying to find someone to sublease that extra space to? What are you recommending?
Based on my conversations with brokers, I don't think it's a good time to. It's a good time to think about subleasing, but I would say it's probably not a good time to actually list space for sublease yet. It's way too early. People can't, with a shelter in place, no one's really you're not going to have the touring capability that you would have. There's so much uncertainty right now that I don't think people are in the right space to make decisions. If you do want to sublease, sometimes talking to landlords makes sense, but probably not in this market right now. You could say to a landlord, hey, we're going to evaluate our options and our future with respect to the space, but most tenants wouldn't necessarily reach out to their landlord yet. They'd talk to a seasoned broker to give them some insight. And we do expect, there's a lot of sublease space on the market right now, even before COVID. There's just so many of the deals I was doing before COVID were subleases versus direct deals. And we expect a lot of subleasing activity. And a broker indicated to me, hey, there is some strategy and timing when these subleases get listed. So think about when you list a space, you don't want to be one of 20 subleases in the same area, all listed at the same time. You want to kind of think about when space is going to come out. that's a little bit beyond what I can actually do, but I thought, interesting insight.
That's really good. There's a question that came in from Leah while you were just answering a question. I'll bring it up, but it's a longer question. So if you can't see it, it says, if you were looking at a space prior to COVID and
Mhm.
are negotiating a lease now, is there anything different you should be asking for in this climate?
Yes. So I have several leases that were not postponed and still proceeded. Still, we've actually signed a couple of them during this entire shelter in place. And what in each of those deals, we've had additional concessions and maybe an extra month of rent abatement or increased tenant improvement allowances. There have been extra concessions on each of the deals that I've worked on. It may be too early to tell how rental rates will change. And I think landlords may be reluctant to reduce the rates too much or much below where they are right now. They may be more willing to provide additional free rent periods, additional improvement allowances, things like that at this point. I do think that rates are going to drop. So it may be, certainly when there are a lot more spaces on the market, a lot more competition, and the landlords are competing over less tenants, and you're a creditworthy tenant. I think at that point, working with your broker, you can figure out and be more aggressive with your asks when you're negotiating letters of intent. What I will say, in current deals, if you're negotiating a lease right now, make sure that the landlord, and this is again, if you're a tenant, make sure that the landlord cannot deliver the space while the shelter in place is in effect. So some leases will state that the lease will commence on a fixed date, or the lease will commence when the landlord says that the space is available to the tenant, or the lease will commence when the work is otherwise done. So maybe it's some painting. If you're a tenant and you can't use space right now, you do not want your lease to commence until you can actually utilize the space. So that's something that you want to think about. The other thing to think about is if you're negotiating a service failure provision or service interruption provision, maybe you do want to specifically state that if the premises are not usable due to pandemic or shelter in place orders, maybe you want to make that explicit. I am going to be following that very closely to see how that changes in the market, if it does. But if I were a tenant, I would be asking for that. And certainly I'm going to be asking for that for tenants. I'm not so confident, though, that that will become a market norm because I don't know that it's insurable. And most leases need to be financeable for institutional landlords. So we'll see. I'm interested in that from an academic perspective, and also just practically speaking, I think it would be really important to have that protection so that next time I'm pulling a lease, we have something that I can point to and say, aha, you have some express relief.
Leah's question was an excellent one, and in part because it just sort of highlights and shifts the perspective to the other side of things. It's where, what if I am in the middle of looking for a lease, and in a way that it's kind of a blessing that you didn't sign it right before
Mm-hmm.
the shelter in place orders came out. And I know we're all anxious to get back to work and get the economy moving again, but the reality is that we still don't know if it's safe. And we also don't know, once we get back to work, how long, it'll be, and what if there is going to be the second wave of where we'd have to be sheltered in place. So for,
Mm-hmm.
I guess, tenants who are negotiating leases now, I think putting an extra emphasis on this clause that may otherwise not have been even on people's minds 6 months ago, probably a good thing to do in case we're required to do this again in the future, or at least in the
Yeah,
near-term future.
I agree. I agree. You also said something else that triggers just a thought that a lot of my clients are thinking about, which is when we do go back to work, how is work going to change? How is workplace going to change? It used to be that for purposes of cost saving measures and other measures, open office, for example, is really, really popular. And a lot of times the density is something like, one person per 115 rentable square feet. Well, I think that people coming back are going to want a little bit more space in their workspace. Some of my clients, larger clients, are thinking about, well, are we going to have a hygienist on staff? How do we think about workplace and safety and companies generally want their employees to, wellness is important. That's why, cafeterias and how are we going to make a workplace that is going to make our employees feel safe and valued? Those are all conversations that a lot of tenants are having right now. And I still think open office is going to remain, but I do think it's going to be a little bit less dense. And I think that there will be a different focus on sanitation and how to keep people, just a safer distance. And then
workplace distancing.
Yeah, workplace distancing. Yes, I mean, sometimes you're literally sitting, elbow to elbow with somebody on a bench. Landlords also probably are going to enhance their building janitorial, perhaps. So that might increase operating expenses. It'll be interesting to see how that plays out in the market, to see if that becomes a norm or, if most of that is going to be tenant driven. But people are thinking about work differently. I know some tenants are also thinking about, this we're all doing this work from home experiment. And a lot of people are realizing, hey, it's not so bad for a good number of our employees. And if this can help reduce our costs somewhat, then we're for it, as long as we can figure out how to make that work. I do expect there will be some people that just stay working from home, but I do think overall that people will keep their offices. For collaboration, maybe the nature of how they use their offices will change. I think there'll also be some office sharing where, Susan and Tina come in on Tuesday and Thursday, and Rochelle and, Bob come in on Monday and Friday.
That makes sense. So definitely something for all of us to start thinking about. And that's a good point. Now, if we're thinking about this from a landlord's perspective and we shift gears a little bit, anything that you want to recommend to landlords who are maybe getting letters, or how do they respond to the tenants' requests for rent relief?
Yeah, so landlords have to think about, I actually have some landlord clients that don't have a lender, and they have more flexibility to decide what they want to do with their tenants and how they want to respond. But I have some landlords that have lenders, and they have very strict covenants in their loans, and they actually cannot amend the lease or grant express rent abatement without working through their lender. So those landlords are being more cautious, which is, hey, we're going to follow the law and we're going to try to, cooperate and figure out what we can do. But if those landlords can provide some deferment of the rent and still get repaid, they may work something out like that. But in general, I'm not seeing a lot of flexibility with most of the landlords that I'm working with that can offer any express abatement. I think it's still too early to be to really see what'll happen, because it's April. Or April rent was just due 2 weeks ago. Some tenants paid and some tenants didn't. We'll see what happens in May, and then is this going to get extended through May until June? We'll see what happens in June. From a landlord's perspective, my advice is, in general, you need to make sure that you're not defaulting under your obligations in your loan, because it also is not going to help a tenant if you are no longer the landlord. Now the building is bank owned. But you need to start having a conversation with your lender if you think that your tenants really aren't going to pay. And then figure out what's a solution that would allow you to maintain this relationship with your tenant. How can you figure out what's a win-win solution for your tenants, preserve this long-term relationship, and continue your rental stream and also comply with your loan? It's a complex decision, and it will also depend on the tenants and who, how viable they are, how long their lease term is, and how great of a tenant they've been. Have they always performed? Are they always late? Are they always defaulting? Or are they just a stellar tenant that you want to have a long-term relationship with? I have a client that has had some tenants that have been in the space for 20 years, and they fully expect that they're going to be there for a long time. Those
Right.
tenants come and ask for some sort of relief. I think the landlord is going to want to work with them.
Yeah. Well, it's a good reminder that at the end of the day, we're dealing with people, and this is a relationship like anything else. And it's hopefully it's a good relationship, and one that both parties want to preserve. So these are really good reminders. And I think this would be a good time. Tell us a little bit about, first of all, the kind of work that you guys do specifically, and if someone has questions who's watching this and might need some help, or if they have further questions, what can they reach out to you for? Who can you help, and how can they contact you?
Yeah, so people can email me. You can flash my email address on the screen if you want. But just to give you a little bit of what I do, I'm a commercial real estate lawyer. Most of my practice is dedicated to commercial leases. I do represent quite a number of tenants, and I do a lot of office leasing and R&D leasing, industrial leases, and some retail leases. But I also do represent landlords in office leasing. Happy to have conversations with folks if they just want to understand, if they read the lease and have a question, what does something mean? Give me a call. I'm happy to have some of those conversations with folks. And if they, want some advice as to how to approach someone, happy to have those conversations as well. I've been having a lot of those conversations, and generally can help. And if I can't help, someone on my team can.
Well, thank you for the offer, and I'm sure people will take you up on it, because it's not often that an attorney will say, call me anytime, and I'll try to answer your questions. So it's very kind of you to do at this moment. And I think that that's a role that you've always played in our professional community. And having had a chance to know you and hear about the work that you do, I think just in your personality, how you bring this calm and peacefulness to an otherwise emotionally charged topic, especially at a time like this. And I got to say, that picture behind you is also reinforcing and calm at an otherwise
perfect shelter in place painting there.
Right. I mean, it's we're all talking about various degrees of storms, financial storm,
Yeah.
and this kind of storm, and there's just this perfectly calm picture. So thank you for bringing a little bit of calm to this
My
topic.
pleasure.
And hopefully to
Yeah,
folks
thank
who
you.
are looking for some assistance, they can get some help as well. Krista, any kind of parting thoughts that you'd want to leave our audience with?
No, I think the only thing I'll say is, when it comes to your lease, ultimately just think about what's your long-term goal with respect to the space, and understanding, who the parties are, and kind of thinking very holistically about the space is going to really help inform the best decision for you. And that just because you heard someone else, discussing some other arrangement that might work for them, but what works for you might be quite different. And you need to really think through what is the best approach for you, and how can you best get there with the landlord or the tenant that you have.
All good advice. Krista, thanks again. It was really
Thank
great
you.
having you on, and
Thanks.
hope you guys find a little bit of calm as well in the flood of work that you're getting.
Thank you very much. I appreciate the opportunity to be here and do a Facebook Live.
It was a
Awesome.
first for everything.
Thank you.
Thanks,
Okay.
Krista. Be well.